are sort of in this legal limbo, neither prisoners of war nor criminals, and yet held indefinitely by the government for questioning. So really that's one of the current issues right now, is whether principles of the Constitution are going to apply to people in that situation or not. Eminent domain has to do with the government's power to take private property for public use, but it also limits that power by saying the government has to provide just compensation, such as market value for houses they want to buy in order to put roads through and that sort of thing. This was used most extensively to build railroads and automobile roads during the late 18th and early to mid 19th century, or I should say 19th and early to mid 20th century, and continues to occasionally come up. My house growing up was purchased under this principle from us and then knocked down to make way for a water processing plant. Unfortunately, one of the officials involved embezzled the several $1 million involved in the project, and that water treatment facility, or the I should say pumping station, never got built. So for the last 12 years, it's all been vacant lots, with our old trees and whatnot still standing, still growing apples and whatnot. I occasionally visit over there just to kind of take in the ridiculousness of the situation. All right, Sixth Amendment. Within this amendment includes the rights to a speedy trial, on that same principle that the accused person is presumed innocent until proven guilty. A quote I like on this is that justice delayed is justice denied. Basically saying you're already being punished if you've been put in prison upon arrest, and there's nothing the government can do to really pay you back for your time you spent in prison, waiting for your trial, or the bail you had to pay in order to get out of prison in the meantime. Public trials, there are many examples. While the colonists were coming over to the Americas, in England there was something called the Star Chamber that British King Charles I used to conduct secret trials in the 1630s, just when colonization was starting up, in order to just suppress public knowledge of and revolt against his political maneuvering. So the first Americans saw this as a very needed amendment and very very needed guarantee of freedom. You have the right to trial by an impartial local jury. One of those things specifically mentioned in the Declaration of Independence as a grievance against the King of England was these trials without juries that would happen in England. Someone would be accused of a crime, perhaps against the crown, and would be shipped out to England and tried by Englishmen. I mean, the colonists themselves were, for the large part, still Englishmen, but having the trial in England was seen as fundamentally unjust. Trial by jury is actually becoming rarer, maybe a surprise. Interestingly enough, only 4.3% of federal criminal charges were brought to conclusion by juries. This is 2002. Compare that with 10.4% in 1988. Why? Because most criminal cases are now being decided by plea bargains, in which an accused person pleads guilty in exchange for a smaller sentence. And the government sees this as beneficial because it reduces the costs of a long trial. Witnesses cannot testify in secret against the defendant. They have to do so in open court with the defendant or defendants counsel present. The defendant can call witnesses in his or her favor and have the assistance of legal counsel, having a lawyer. And more recently, in a principle established in Gideon versus Wainwright, 1963, if a person cannot afford a lawyer, one will be appointed by the court. This is what a public defendant is. Really interesting story of Clarence Earl Gideon, who was an uneducated man who appealed directly to the Supreme Court after he'd been jailed because he'd felt like without the ability to properly defend him against the accusations, he was basically put in prison for really his lack of lawyer more than his guilt. So he wrote directly to the Supreme Court a petition for writ of habeas corpus, if you remember that term from earlier, and was granted a retrial based on this, and given actually won that case. All right, Seventh Amendment, trial by jury. Again, this is now not just applying to criminal cases, but to civil cases as well. Again, free from secret trials, and that the jury has to be made up of your peers, which happens with more or less success in the United States. Eighth Amendment. Free from cruel and unusual punishment as well as excessive bail, although the excessive bail thing is kind of a moot point nowadays because the Supreme Court has ruled in favor of laws that allow courts to deny bail altogether to some defendants if they're deemed to be potentially dangerous or a sort of an escape danger if they're going to leave the country or something. If that seems to overturn the principle of innocent until proven guilty, I'd say you're probably right. But remember, the court has consistently ruled that because of the limitations inherent in our rights, this may be one of those times in which corporate security overrules personal liberty. Whether or not the death penalty is cruel and unusual punishment is an ongoing debate. The court has issued some opinions on this, although none completely decisively. I'm not saying like forever and always the death penalty is wrong or forever and always it's right. But yeah, it is very much a current issue. Ninth Amendment has to do with this category of unenumerated rights, basically those rights that people have generally that are not named in the Constitution, but that the government needs to not mess with. Eventually, the right to privacy becomes one of these unenumerated rights. That is, it's not mentioned anywhere in the Constitution, but it's extrapolated out from the Constitution. Probably the Fourth Amendment, the 14th Amendment have more to do with this than the Ninth specifically, but the Ninth Amendment allows such rights to sort of become part of constitutional law, even if there's not an amendment involved. Really, it's through the heritage, I guess you could say, of Supreme Court decisions that now there is a right to privacy, so that the government can't be involved in decisions about things like marriage and contraception and abortion as of 1973. Obviously, it's still hotly contested and debated, but there's certainly something good about this when it comes to the issue of eugenics. The government, well, at least some people in government at various times have attempted to pass legislation that would allow for the sterilization of supposedly unfit people who could be homeless or mentally disturbed, or those committing crimes, or in some cases just those of supposedly inferior races.